Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is Stephen Thaman. He is a professor emeritus of St. Louis University School of Law, and today he's speaking with us from Berlin. Welcome, Professor Thaman.
Thank you. Pleasure to be here.
So first, I just have to ask, why are you in Berlin? You are a retired professor, obviously, from St. Louis, but what brought you to Berlin?
Well, it's a long story, but my first major was German literature, and I studied in Germany in the 1960s. And then I got a law degree at Berkeley. I switched to law sometime in about 1972, got my law degree and was a public defender for 11 years in California. And then I went back to Europe. I got a Fulbright as a public defender to go to Europe because I knew German. And so I was one of the two non-professors who got German Fulbrights that year. The other one was a puppeteer.
Oh, interesting. Who knew puppeteers got Fulbrights?
But I spent, in my head public defender, I was quite a high up public defender then and had a lot of experience and was considered to be probably one of the best in the office. And I said, can I take a year's leave of absence? And he said, no, you have to quit and start again as a public defender one. And I said, okay, I quit.
Wow.
So I didn't have anything to bring me back to California. So I stayed 8 years in Europe and got a PhD in German law in that time and worked at the European Commission of Human Rights and did lecturing around Germany about American criminal procedure and criminal law. Eventually got this doctorate and also worked in Sicily at an institute founded by a famous American professor, Sharif Bassiuni, that dealt with international criminal law originally. And he was one of the main persons that pushed for the International Criminal Court. So I got all this experience. And then I spent 3 years in Russia because I'd met a woman and so I learned Russian and lived for 3 years in Moscow. And then I decided to put my name in for a teaching job. And I got one offer at St. Louis University.
The rest is history. My goodness.
And Berlin was always one of my favorite cities, well, after a while. And I had a lot of friends here. And I've never really taught, except the Fulbright, I was here. But after that, it's an exciting city and much more livable now than California, which, it's so expensive. It's kind of the quality of life has gone down there. But here it's still affordable and everything. So that's why I'm here. And actually, I do a lot more stuff in Europe than in the US. I'm going at the end of the month to Modena, Italy for a conference. So I do a lot of conferences. I used to teach a lot here before COVID, not so much now after COVID, teaching courses in comparative criminal procedure and so on. So, I just kind of feel more at home in Europe.
Well, you have a lot of reason to, and I love the fact that all of this really stemmed from your saying, I quit, which is
really
sometimes important for our students who are listening to hear that sometimes we need to.
And my daughter was already at that time, like, what is it, 1980s. She was already 18 and kind of she was living in Wisconsin with her mother. And so I didn't have to go back and take care of her so much. So I was free to, have bohemian life for 8 years.
Well, that's exciting. And while you're there, still staying very much immersed in comparative criminal law, because you just published Criminal Procedure, a Comparative Approach, a first edition with Aspen. So congratulations on that. And I wonder if you can tell us some of the inspiration for that book, why you thought the book was necessary, and who might consider using it.
Yeah, well, I did a little comparative book, but only on European law in 2008, second edition, 98 and 2000. But it was a small book by Carolina Academic Press, and it was mainly used, I think, in Europe or in comparative criminal procedure classes in the US. It was translated into Chinese and used in China for some reason. But I thought we needed one with American law because American law was so influential, especially in the 60s and 70s with Miranda and all that other countries want to know about American law too. So I started, and I just assumed my old publisher would want to publish it. So I just started collecting all these cases, translating translating them into English, the ones that weren't in English already, and amassed this huge amount of stuff. And then the other publisher said, no, it's too big. We can't publish it. So I then shopped it around to the big casebook, and Aspen, I love Aspen. They said, we'll give it a try. So to get back to the reason I think it's important is I've always said this even before. I don't think you can understand your own law, your own criminal procedure or civil procedure, whatever, just by learning about it in your own country without a comparative perspective on it. Because the only way you can see what is good about your system and what is bad is by being able to compare it to other similar countries, democratic countries. And most of the countries that I deal with here are democratic countries or ones that tried to be democratic and failed, like Russia, whose cases are still in the European Court of Human Rights because Russia still is, I think they've withdrawn, but they still have a lot of cases that criticize. So what you have is really a large amount of material to compare American law with from real democratic countries that have different systems. And also another thing is comparing it, when do systems become less democratic or let's put it this way, seem to care less about due process and more about, just convicting people as quickly and simply as possible. So I really think, number one, I only understood my system, the good and bad, when I started studying other systems. So it's all really from my own experience. I didn't know anything about German law. I was a German literature major. I didn't know the German legal vocabulary until I went on my Fulbright, went back and started getting into this, started doing the comparative stuff. So, and especially with the US, knowing international human rights law, because we don't ratify these treaties. So our Supreme Court doesn't have to abide by anything that they don't think is human rights. And so that's why we're, you call American exceptionalism. That's why we're so strange in not every way, but in many ways compared to, let's say, European democracies, which are probably the closest thing to our democracies. I mean, kind of Western democracies, industrial, fairly well-off countries, prosperous countries. And they come from a completely different tradition, which I don't support theoretically. The inquisitorial position, the tradition of using a lot of written testimony, letting all the hearsay in. I'm really a supporter of jury trial in our adversarial system. But on the other hand, and this is one of the motifs that goes through the book, on the other hand, our punishment system is so draconian compared to any of the punishment systems in Western Europe, well, really in Europe, except Belarus, and in Latin America, except Cuba. They don't have the death penalty, for instance. They don't even have life imprisonment because they are controlled, and even Russia got rid of death penalty or put a moratorium on to join the Council of Europe now, and they'll probably reintroduce it soon. Who knows? But so far they haven't. So we're kind of an oddball country when you compare some aspects of our system. Others are very good, jury trial in theory, but we don't hardly have any jury trials anymore because of plea bargaining. And all the Europeans tell me that. You talk about jury trial, but you don't even have any.
That's interesting.
Right.
Yeah.
They're right. They said, where would you rather be tried if you were either guilty or innocent of a serious crime like murder or something? Of course, Europe, I might be convicted, but I'll get at least if I'm guilty, I'll get a punishment that is not for life or even worse. In the United States, you'll probably be convicted even if you're innocent too, because, our plea bargaining system is so coercive that they threaten you with 50 years and offer you 10. So the guilty are going to take that, but the innocent are going to take it too. So we have a lot of serious problems in our system, even though theoretically it's beautiful on paper. And so I compare a lot of the things we don't have, like in the second volume, reasoned judgments. The Europeans claim, even both conservative and progressive Europeans claim our system is better because our judges have to give reasons, whereas a jury doesn't. So I try to, in a very complicated chapter, I try to show that, look, our system, if it works properly with good jury instructions, why the jury decided the way they did. They don't have to give extra reasons. And, Germany, for instance, they don't even have a verbatim transcript of their trials. So the higher court judges don't even know really all the details of what happened in the trial. So I compare the good and the bad of both systems. No system, probably because I was a defense lawyer, no system comes out well well. All the systems I criticize in many ways, but I praise them in other ways. We still have probably one of the best systems for exclusion of evidence, which goes back to the 1960s. And even the Miranda, although Miranda's been adopted in almost all democratic countries now, that's still pretty good in the United States. But the right to counsel has suffered terribly. The cutting of funding for public defenders' offices, the quality of defense counsel, I think today is much inferior than it was when I was practicing, which I always said was the halcyon days of being a defense lawyer. Well-funded public defenders' offices. We had 35 trained criminal investigators, former policemen,
Wow, that's incredible.
and we had a system of punishment in California in those days where if your client said, I'm not guilty, or you thought they don't have a very good case, you'd go to trial because the difference between the maximum and the minimum was only 2 years, except for first-degree murder. So 5 years or 7 years, 10 years or 12 years,
and people would go to trial over that. Boy, they'd never go to trial over a 2-year differential now.
Now the difference is 2 and 50 or so, no, like 10 and 50. It's scary to go to trial. But if it's only 5 or 7 and they're not offering you probation,
I see.
You may as well roll the dice,
Okay.
because it's only a 24-month difference. And then if you're a good prisoner, you even get out earlier. So I had like 60 trials, and a couple of years I was just doing juvenile, so with notes. So in about 9 years, I'd have about 6 or 7 trials a year. And when I talk to public defenders and even prosecutors now, they're lucky to get one trial a year, a jury trial, real jury trial. I'm not sure how it is in Texas, and therefore the quality of prosecutors and defense lawyers is going down. They don't know they don't have trial experience anymore.
Yeah, at least for jury trials, sure.
Plea bargaining, it wasn't even taught when I went to law school. In fact, I learned plea bargaining the first day in municipal court in Oakland, California, where they gave me a bunch of cases and said, go in and plea bargain. I said, how do I do that? Just go learn.
That's interesting. Yeah, I think what I hear more from a public defender standpoint is just that there's a shortage nationally, that they can't get enough. A lot of empty positions, which of course impedes right to counsel, which of course delays adjudication, people sitting in jail without any opportunity to defend themselves. I'm wondering, the public defender system, when it works, or even just right to counsel generally, I think is certainly great here in the States, right to counsel for criminal cases. But is that something that is replicated internationally? I mean, do other countries have that same right to counsel for criminal matters?
Yeah, theoretically, the U.S. is the best. You have a right to counsel for anything where you could go to jail. No, it's not so good in Europe, but they do have a mandatory right to counsel for if you're in custody or if you're facing, up over 10 years or something, or if the victim has counsel, because the victims have more rights in the United States, in Europe than they do in the United States. So then they have a mandatory right, and they can't waive it like some of our crazy people do who are faced with death penalty. They waive the right to counsel and say, I want to be executed, or, there's none of that. But they don't have public defender's office. South America, Latin America does. Brazil was the first country to introduce public defenders, and the second was Los Angeles, and the third was Alameda County, where I worked under Earl Warren when he was district attorney of Oakland, of Alameda County. He set up the public defender's office. So we have this long tradition, but not all states. I think even when I was practicing, I'm not even sure, did Texas have public defenders back in the 70s?
Oh, goodness. I don't know. I'm new to Texas.
Yeah. But some states didn't have them, and we had them only in the big metropolitan areas. And otherwise, you'd have a court-appointed system in the small counties. There's a lot of small counties in California. I really think, and the problem now is that they're not funding. Ours is funded by the county. Some are funded by states. They're not funding them to the same extent that they did before.
No, that's certainly true.
Oakland was 350,000 population. Now it's 450, like 100,000 more. We had 130 lawyers, and they have like 80 now. And Oakland is still one of the most dangerous cities in the country.
And they certainly don't have 35 investigators.
No, they have 18 or something. I mean, they still have some investigators. When I was doing the clinic, I read you did clinical work, right?
Yes, I did.
I ran the clinic in St. St. Louis my first 5 years or so, and they didn't even have trained police as their investigators. They had students or law students. You didn't even get discovery of the police report until after the preliminary hearing. I mean, it's just horrible. And I couldn't believe it. I was saying, how can you even defend a case or investigate it if you don't even know what's happening until a month before the trial? So it's really comparing California with Missouri. St. Louis was just, my hair was standing on end. I had hair then.
Yeah, I didn't know how to say, like, well, looking at you now.
Well, I still got a little bit. I cut it short because it doesn't look good anymore. But
So let's get back to the book. I mean, clearly we could talk for hours about the differences and the similarities between the US system and its strengths and weaknesses and those around the world that you've studied. But if we're thinking about the Criminal Procedure, a Comparative Approach first edition, who should read this book or use this book in their class? Who are the end users you anticipate will gain the most from use of this book?
well, I mean, I really think, and it was a gamble, I think, by Aspen to have this kind of a book because it's the first one that's designed to be used in introductory American criminal procedure classes. When I presented it to them, they said, can you redo it so it's heavy-ended on U.S. law? So what I did is I put a lot more U.S. law in and put it first. I think every professor should take a look at it and just see if they can deal with it. I mean, because it's not easy to teach this like it is to teach, how it is in law schools. Somebody's hired and there's a slot in criminal procedure and maybe they've never tried a criminal case and yet they got
Don't tell our secrets.
and they have to go teach it. They have to go teach it. But it might be challenging for a brand new professor who even has to learn about get into the nuts and bolts of American criminal procedure. But I think anybody that's had some experience at teaching the regular class should really give it a try. I mean, take a look at it. And I'm working on different syllabuses. So a syllabus for big classes and then shorter. And I'm going to try to give some insights on, well, if I have too much foreign stuff for you, here's how you can cut it down maybe, but the main thing is that this is thought to be a historical and critical look at criminal procedure and not just a kind of hermetically sealed investigation of how the US does it, because sure, and that's like most of your traditional courses, you can have a good shot at passing the bar if you take that course, and you'll be an okay criminal lawyer in the individual case because you know the case law. But technically, I think in most bar associations say lawyers should not only just apply the law, they should try to improve the law. They should try to reform the law. And heavens, I think everybody should realize U.S. criminal procedure law needs reform. I try to look for the new cases. The Supreme Court doesn't even hardly decide any more cases in criminal procedure. It's all gun laws or, different other stuff that's more political. And I think if criminal procedure is going to just kind of dry up and be this plea bargaining system, which, the two cases in 2014, I think it was Loeffler versus Cooper and Missouri versus Fry, they basically said, well, our system is plea bargaining. It's not jury trial anymore. But I mean, this means it's become an administrative top-down system that's even worse than the more written inquisitorial trials you find in Europe now, because they are not as coercive. You're going to be convicted probably because professional judges are, they're more likely to adopt what the prosecutor wants and so on than a jury necessarily is, although some, but I really think that only if you kind of know options. And my last chapter is about reform. And I really think some teachers might want to teach that, but it's about how can we change the system that convicts so many innocent people when they do go to trial, and even more when they plea bargain. They're not being convicted for murder or rape so much when they plea bargain, but they're convicted, for maybe it's a robbery or maybe it's just big theft or 3 strikes and you're out, but something they may not have done this time, but they take the deal because the punishments are so horrible. But so the idea is to basically the leitmotifs of this book are, number one, differentiating between due process, presumption of innocence, taking presumption of innocence, proof beyond a reasonable doubt seriously. And this is George Packer's old dichotomy from 1960s, 66. The due process approach, which he saw in the Warren Court, the famous Warren Court decisions, Miranda, Mapp versus Ohio, Gideon versus Wainwright, kind of strengthening the protections for the accused in systems that, as we know, didn't work well at all. And even having not just white males on the jury, things like that. And then the crime control approach. And maybe I'm a little bit too political myself or too much pro-defense, but I do kind of say when the crime control approach kind of took over the majority of the Supreme Court, because I think it pretty much, and I don't think it's exaggerating. They even say it themselves. And as I said, the Chief Justice Rehnquist is amazing when you read it. He says, we are not able to control the police conduct. We don't have a chancellor's foot veto over police practices. And I wonder if the Supreme Court can't tell the police what to do. How can they decide human rights cases? Because the police are, to secondary effect, prosecutors are the ones that they're the executive power, and oppressive countries, dictatorships, countries use criminal law as a weapon against the people they don't like, against criminals, of course. Let's hope everybody uses it, but against people they don't like. And another leitmotif is what I call enemy criminal procedure. In the introductory chapter, I go through old archetypes of criminal procedure. Roman law had this. Medieval German law had it. You had the nobility didn't have to face the death penalty or torture. The poor people did, things like that.
Oh, yeah.
And of course, when we started out with the Constitution, we had a whole group of people that had no rights. Slaves and women too, but I think women were at least protected by the criminal law. They didn't have a right to vote or to be on juries and so on. And the death penalty was mainly used against slaves in the early days. And when we had death penalty for rape, it was mainly used for blacks who were charged with raping white women. And Michelle Robinson's book, The New Jim Crow, is really saying, look, we still have this enemy criminal law. Now the enemies are the so-called criminals. It's not just racially defined, but still it gobbles up more minorities. So all countries have had this, the highwaymen in the Middle Ages, they were outside of, you could kill them or something, the blasphemers or something. And now, quite frankly, and I wrote that the idea of enemy of the people really started with Stalin and Hitler, the really enemies of the people. But now, Trump is using the same language. He calls the internal enemy. This is really going back to, language that was used by the Bolshevik Party to get rid of what they thought their enemies were, the bourgeoisie and so on. And it's scary, and criminal law used as a tool, and this is why and this enemy criminal procedure is meant to be something not just U.S. This is something that's always lurked within criminal law and criminal procedure. Is the reason you need these protections, these due process protections, is it can be manipulated by the executive branch if they want to. And the other leitmotifs were really differentiating between preventive police law and what the Europeans call, or the civil law countries call, repressive criminal procedure. So the idea being police, when they're out there on the streets, and it makes sense, they're trying to protect the public walking the beat. If they think somebody's in danger, they can do something without a warrant. Or if they think somebody's armed or dangerous, like Terry frisks, they can. The idea of preventive police law is not governed by the criminal procedure code in Europe. It's governed by police law. But then once a crime has been committed, then they almost don't even let police investigate, because police are there more of a military. In some countries, they're quasi-military, like the old civil guard in Spain and so on. But
so they're there to prevent the crime.
Yeah, but once a crime's been committed, then the police can respond to the scene, gather the evidence, rope off the scene, take fingerprints, and then they got to give it to a legally trained investigator or investigating magistrate judge who takes over. They don't trust police to prepare evidence. So the idea of the different roles of police, whether preventive, where you don't have as many protections, you only need reasonable suspicion to detain somebody to see if they might be suspicious. And then especially I include in all these areas special laws for anti-terrorism and for organized crime, which I'm not sure to what extent the current casebooks do that. Sometimes there's a different course called anti-terrorism law or preventive, but I think you should really compare it, because it's always a slippery slope. Once you call somebody terrorists, then you use these laws that don't have protections, because if you're thinking of Al-Qaeda or you're thinking of something that really is a national security threat, once you start using the label terrorists on, like in Russia, on dissidents or people that criticize the government, or even now, Trump has said that whatever he calls the anti-fascist, that would be, and let's face it, if someone were to ask you, are you anti-fascist? You would say, yes, I don't want a fascist government. We'd all be anti-fascist theoretically. We're not out there, we're not in some little group preparing some action, but we should all be anti-fascists. Now all of us technically could suffer if we say fascism is not a good thing, or dictatorship is not a good thing, or whatever kind of dictatorship. Totalitarianism is not a good thing. That preventive is something, and we talk about exigent circumstances. We have these exceptions the same way in Europe, but the Supreme Court is not very theoretical. They're not legal scholars really in criminal procedure. We may have had some in the past. I'm not sure, but basically they're just judges that end up getting on the Supreme Court after a long, more or less long. And I think bringing the European stuff in enables you to think more about what is exigent circumstances. When should it apply? Because it's really police law. It's really something that it's a carte blanche given to the police to protect humans, to run into a house if there's a fire, to do things that are really dangerous. So that, I understand, this is one of the other kind of leitmotifs, which is laid out first in that first chapter, and then you follow it through the book as it comes in.
I love that you give context to our system and that you encourage students to think critically about what is working in our system and perhaps what could work better. And for those who are thinking about adopting the book, there's an online appendix that has high court opinions and statutory law from other countries, but it's all translated to English. There's a glossary of terms and concepts translated from French, German, Italian, Russian, and Spanish. And then you give some chapter end suggestions for additional U.S. and comparative reading that students and faculty may want to do. The people we are graduating from law schools are the ones that we hope will reform the system moving forward. So I think that your book, Criminal Procedure, A Comparative Approach, first edition, will be very helpful in assisting them in doing that. Now, before we conclude, I wanted to ask you the question that I ask all my guests, and that is, what are your predictions for the future of legal education in the U.S. in the coming decade?
Okay. Yeah. Well, I haven't been teaching in the U.S. since 2017. I think that was my last course, but so it's been 8 years. But I'm just hoping that we either continue or try to keep up high quality courses that challenge students and that don't try to indoctrinate them, into some kind of belief system. The great thing about U.S. law and U.S. history is in this area, criminal procedure, is we were in the forefront. We were a model for all emerging democracies, and after World War II, democracies that were, reformed after fascism or communism. But we aren't that anymore. Something's happened where we're not a beacon for other countries anymore in this particular area, and there may be other areas too. So, I think in hiring professors, try to get professors that have a critical edge, and they don't have to be right or left or anything like that. If you look at our Constitution, they got to believe in things like due process, the presumption of innocence, proof beyond a reasonable doubt. All these have been declared as being human rights, even in the United States, where we don't really have a right to life. And that they should try to get their students to critically look at this stuff and to really say, well, look, where can it be changed? Shall we change? How can we change it? And so you get really dynamic lawyers coming out. We need more public defenders to say maybe students don't want to be defense lawyers anymore because it's not interesting. There are no trials. It's a rigged system. We have to get a system where they can really have trials, where you can learn how to be a lawyer and you can maybe save some innocent people by aggressive, but also on the prosecution side, which because it's become a heavily executive controlled system now, they have it good, but they should come in with more critical view too, not just of how can, I remember that it's a trouble. Bad aspect of our adversary system, notches on the belt, how many of you won? You don't try cases that are difficult, try to plead, but you should try difficult cases. I really think that's the way I remember law school being back in 1970s when I went to law school. It was a bubbling place of all kinds of different ideas. And I went to Berkeley. Berkeley wasn't. We had professors that were extremely conservative. My criminal procedure professor was the main spokesperson for creationism later on. I mean, Berkeley wasn't, I didn't know at the time, but I didn't think he was very good, actually. But I
Well,
mean,
I hear what you're saying. We want
yeah.
to have an engaged student population and faculty population that are exploring legal theories, application of laws, reform in a way that's active and balanced on both sides. And that's how we're going to effect change most effectively.
And I really think right now with the pressure by the federal government, or mainly the executive, put on our universities to toe the line and suppress free speech and not teach certain subjects or not emphasize certain things. I mean, the future, if that continues, nobody might use my book.
Well, let's hope that's not the case for you and for Aspen. So thank
Yeah, I
you so
know.
much, Professor Thaman, for
Okay.
spending some time with us and sharing news of your book, Criminal Procedure, A Comparative Approach, first edition. Best of luck to you as you celebrate fall in Berlin. And if you want to listen to additional thought leaders in legal education, in the US and globally. You can find episodes of Aspen Leading Edge on YouTube and your favorite podcast channels. Thank you.
Okay, thank you very much.